Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, in this session today we would be discussing on parliamentary privileges. We would be discussing on the parliamentary privileges being given to the member of the parliament, as well as we would be discussing on in what conditions the parliamentary privileges given to the MPs could be violated. Dear friends, this is the lecture of the discussion, that is, this is the topic of the discussion we would be carrying through this lecture today. But before starting this lecture on parliamentary privileges, I would like to tell you all that in previous session we talked about anti-defection law. We discussed about the anti-defection law as a whole, but due to the paucity of time, some of the points were left which we were not able to discuss. So dear friends, we would be discussing on the left portion of the anti-defection law, and then we would be continuing further with the parliamentary privileges. Dear friends, for this discussion we have again with us in our studios Dr. Rakesh Kumar. Dr. Rakesh Kumar is Assistant Professor in University School of Law and Legal Studies, Guru Gobind Singh IP University. So, I would like to welcome our guest, Dr. Rakesh Kumar, under whose guidance we would be first discussing on anti-defection law, and then we would be continuing with our lecture on parliamentary privileges. So, I would like to welcome our guest, Dr. Rakesh Kumar. Sir, welcome to the EDSET lecture.
Thank you, Geetika. Good morning, listeners. In my previous lectures on anti-defections law, I have given you the detailed analysis as to what are the genesis of the anti-defections law under the Indian provisions, and how the various kind of measures was being adopted by the parliament to check this kind of unethical or unprincipled defections which was taking place purely on the lure of the office, or for the just to somehow get the any kind of the monetary or the other political considerations. And here it has assumed such a dimension that here the parliament was forced to appoint a committee under the chairmanship of late Baibi Chauhan committee, and that committee was popularly known as the Committee on Defections, and this committee has given the various recommendations pertaining to the ethical, political as well the constitutional recommendation as to what measure has to be adopted for the purpose of checking the provisions of defections by the elected members of the parliament and state legislatures. And here the parliament has tried to implement this policy by the first taking the measures in the form of the Constitution's 39th Amendment Bill, but that bill could not be passed because of the dissolutions of the House, and again the attempt was being made by the Constitution's 49th Amendment Bill, but that bill could also could not see the light of the day because of the oppositions by the Janata Party members. And it is only in 1984 parliamentary elections where the Rajiv Gandhi was leading the Congress party. Then he has made a promise to electorate that once his government will come into power, then they will introduce significant measures regarding the curbing this kind of the unethical or unprincipled defections which was taking for the lure of the office. And if you see the statement object which was attached with the 52nd Amendment Act, then it was stated before on the floor of the parliament that the evil of defection has undermined the very foundations on which our democracy is based. So after discussing this, here the parliament has passed the 52nd Amendment Act in 1985, which provided for the anti-defections law, and this provision has also introduced change under the Article 101 as well as the so Article 102 as well as the other provisions pertaining to the defections by the members of the state legislatures. And it is in the previous class I have also explained to you the basic scheme of the anti-defections law. Under the basic scheme I have stated to you that here it provided for the checking the three kind of defections, and the first ground which was stated in the 10th schedule of the constitution that if the elected members of the parliament or the nominated member who belongs to the political party voluntarily relinquish the membership of the party to which he belongs, then he will come within the purview of the anti-defections law. Then the second thing which I have discussed regarding if any elected members of the political party, if he vote or abstain from voting against the directions of whip which was issued by the political party, and if such such violation is not being condoned by the political party within the 15 days, then that case also he will incur the disqualifications. And the third disqualifications pertains to the independent members of the parliament or state legislatures, that if after election if he join any political party, then that case he will also come within the purview of the anti-defections law. And the fourth point pertaining to the nominated member, because the nominated members of the parliament or the state legislature has been given options to join any political party within 6 months from the date on which he assumed the office. And if after 6 months if he join any political party, then in that case he will also come within the purview of the anti-defections law, and he will disqualify as a member of the parliament or state legislature. So after giving you the basic scheme of the 10th schedule of the constitutions, then I started emphasizing on the how the constitutionality of the anti-defections law was being challenged before the Supreme Court in Kyoto Hall Horn case, and how the Supreme Court has upheld the constitutionality of the anti-defections law. Apart from this, in previous lectures I have also given you the some idea as to what kind of the rules which was being framed by the Speaker of the Lok Sabha as well as Chairman of Rajya Sabha for the purpose of checking this provision of anti-defections law, and what kind of the obligation which was being imposed on the elected on the leaders of the political party as to what kind of information he has to provide to the speaker regarding the change in the strength of the legislative party. So apart from this, then I have specifically tried to emphasize on the meaning of the term voluntary relinquishing the membership of the party. And in this context I have started discussing the case of Mahachandra Prasad Singh versus Bihar Legislative Assembly case, and in that case I have given you the some idea as to, because in this case the petitioner Mahachandra Prasad Singh, he was the elected members of the Bihar Legislative Councils on the ticket of the Indian National Congress in 1998, and in 2004 parliamentary election he sought the ticket of the Congress party to contest the election from Maharajganj parliamentary constituency. But once the party has denied him ticket to contest the elections from the Congress as a Congress candidate from Maharajganj parliamentary constituency, then he decided to contest the elections as an independent candidate. And once he contested the election and he lost the elections, then here the complaint was being lodged with the chairman of the Bihar Legislative Council, alleging that he was the elected members of the Indian National Congress and he contested the election as an independent candidate, so he has to be disqualified under the provisions of anti-defections law. And after receiving the complaint from one of the members of the Bihar Legislative Councils, here the chairman of the Bihar Legislative Council has served him the so called notice, and he is being asked to explain his positions, but he did not he personally met to the chairman and he explained the position, but still after giving the proper hearing, here the chairman of the Bihar Legislative Council has decided to disqualify him under the provisions of anti-defections law. So once he is being disqualified, then he challenged the decisions of the chairman of the Bihar Legislative Council by saying that there was violations of the principle of natural justice, because the materials which was relied upon by the chairman of the Bihar Legislative Council was not disclosed to him before disqualifying him under the anti-defections law. And his second contention was that he has not voluntarily given up the membership of the political party to which he belongs, because despite the fact he has contested the election as an independent candidate, he continued to the members of the Bihar Legislative Council or MLC on the ticket of the Congress party, and the party has not taken any disciplinary actions because of the violations of the mandate of the party and to contest the elections. So here the provisions of the sections 2 clause 1 subclause 1 will not come into the play. So despite these contentions, here the Supreme Court has stated that since he has been elected to the legislative council on the ticket of the Indian National Congress, but he contested the parliamentary elections as independent candidate. So the inference can be drawn from this fact that he has voluntarily given up the membership of the political party to which he belongs, belongs, and therefore he will be disqualified under the para 2 clause 1 subclause A of the 10th schedule of the Constitution. And the Supreme Court also reached to the conclusion that there was no violations of the principle of natural justice, because he was given the personal hearing by the chairman of the Bihar Legislative Councils, and he was also being served the so called notice as to why he should not be disqualified under the provisions of the 10th schedule of the Constitution. And it was also admitted fact that he contested the parliamentary elections from the Maharajganj parliamentary constituency as a independent candidate. And so the Supreme Court had reached to the conclusion that in view of the explanations A to the para 2 clause 1 of the 10th schedule of the Constitution, a member shall belongs to the party to which he has been set up as a candidate for contesting the elections for Bihar Legislative Council, and contesting election as a independent candidate after the refusal of the ticket by the party it can be safely be presumed that he has voluntarily given up the membership of the political party to which he belongs. So this is how the terms voluntarily relinquishing the membership of the membership of the party was being explained by the Supreme Court in Maharajganj Prasad Singh versus Bihar Legislative Council. So apart from this, with respect to the anti-defections law, the other issue which has agitated the minds of the court as well the elected members of the parliament and state legislature as to what will be the status of the expelled members. Suppose if any elected members of the parliament or if any elected members and members of the any particular political party, if he indulge in any kind of the anti-disciplinary actions, and if he start towing the lines outside the policy and principles of the party, and if the party as a disciplinary measure had decided to expel him, or if on the request of the that particular political party, if he is being declared as unattached members of the legislative assembly or legislative councils or the members of the parliament, then what will be their status, where after such declarations or such expulsions, whether he continue to be controlled or governed by the provisions of the anti-defections law as provided under the 10th schedule of the Constitution. And this issue was specifically explained by the Supreme Court in G. Vishwanath versus Honorable Speaker Tamil Nadu Legislative Assembly case in year 1996. Here what happened in this case is that the appellant was elected to the Tamil Nadu Legislative Assembly on the ticket of the AIADMK in year 1991. And when he indulged in anti-party activity, then he was expelled from the party in 1994, and thereafter he joined the MDMK party. So after joining the MDMK party, here the complaint was being lodged with the leaders of the AIADMK, and after so once the former complaint was being lodged, then the Speaker of the Tamil Nadu Legislative Assembly has declared him as unattached member of the AIADMK. So after this and after first declaring him as an unattached members of the AIADMK, and afterwards on the basis of the complaint he was being disqualified by the Speaker under the provisions of the para 2 clause 1 subclause A of the 10th schedule of the Constitution under the anti-defections law. So once he was being disqualified, then he challenged the Speaker decision before the court on the various ground, and his first contention was that the para 2 clause 1 subclause A of the 10th schedules come into play only to disqualify members who voluntarily give up the membership of his political party that had set him up as a candidate, and not when he is expelled from the party and declare as unattached members not belonging to any party. And his second contention before the court was that the para 2 clause 1 subclause A of the 10th schedule of the Constitution apply only when the member himself of his own volitions gives up the membership of the political party, and if any member who is thrown out thrown out or who is declared as unattached members, he will not come within the purview of the para 2 clause 1 subclause A of the 10th schedule of the Constitution. But here the Supreme Court has negated his contentions by saying that the para 2 clause 1 subclause A of the 10th schedule of the Constitution read with the explanations clearly point out that the elected members shall continue to belong to the political party to which he was set up as a candidate for the election as such, and such members notwithstanding that he was being thrown out or expelled from the party. And the second point which was emphasized by the Supreme Court in this case was that the throwing out or expulsion is a matter between the members and his party, and it has nothing to do so far as the deeming clause of the 10th schedule of the Constitution is concerned. And the third clarification which was given by the Supreme Court by saying that the action of the political party quoas member has no significance and it cannot impinge on the fictions of law under the 10th schedule of the Constitution. And if you see the kind of observation which was made by the Chief Justice Ahmadi in this case by saying that if the persons belong to the political party that had set up him as a candidate get elected to the House, and thereafter he joins the other political party for whatever reasons, either because of the expulsions or otherwise, then it will presume that he has voluntarily give up the membership of the party to which he belongs and he incurred disqualifications under the 10th schedule of the Constitution. Apart from this, the Supreme Court further observed that being treated as unattached is a matter of more convenience outside the purview of the 10th schedule of the Constitution, and it does not alter the fact to be assumed under the explanations to the para 2 clause 1 subclause A of the 10th schedule of the Constitution. So, such arrangements and the levelling has no legal bearing so far as the 10th schedule of the Constitution is concerned. So, deeming fictions as provided under the explanation 1 to the para 2 clause 1 subclause A of the Constitution is concerned, here it must be given the full effect, for otherwise the expelled members or the any member who is being declared as unattached member will simply escape the rigors of the law by adopting this tactic that since he is being expelled or he is being declared an unattached member, so he ceased to become under the provisions of the anti-defections law. And apart from this, here the one thing also you have to keep in mind with respect to the anti-defections law is that the as far the provisions of the anti-defection law is concerned, here the speaker has been given the power to initiate the suo moto actions against the members of parliament if he come within the purview of the any of the provisions of the 10th schedule of the Constitution. So, despite these novel provisions, here the anti-defections law has somehow failed to check this unprincipled or unethical defections which was taking place on account of the lure of the office or any other monetary or other political considerations. So, as far as the if you see the in totality of the provisions of anti-defections law, so definitely here this provision has somehow checked the independent defections, but it has the same time it has also provided the scope for the realignment of the forces which will provide the strength to the Indian parliamentary democracy. But despite these novel provisions, here some of the defect has been pointed out, and if some of the committee has also given the certain suggestions regarding as to what measure has to be taken for the purpose of plugging the loopholes which has cropped up in the working of the provisions of the 10th schedule of the Constitution. And if you see the recommendation which was given by the Dinesh Goswami committee, so here this Dinesh Goswami committee on electoral reform in year 1990 has made the following recommendations regarding the strengthening the positions of the 10th schedule of the Constitution, and his first recommendation was that nominated member should also be disqualified from being a members of the House if they join any political party even within the 6 months after becoming a member of the House, because what is being prescribed by the 10th schedule of the Constitution that if any members is being nominated as members of the parliament or state legislature, then such member is having option either to joining any political party within 6 months from the date of assuming the membership of that house, and if after 6 months he decide to join any political party, then definitely in that case he will come within the purview of the rigors of the anti-defections law. So, what the Dinesh Goswami committee on the electoral reform has suggested that here this provision should also be extended to the nominated member even he joined any political party within 6 months from the date of assuming the membership of the house. Because here in that case, because here the president has been given power to nominate the members to the Rajya Sabha, and if the government of the day is not having the majority in the Rajya Sabha, then definitely in that case they will nominate the certain members to Rajya Sabha, and they will somehow persuade them to join the political party. So they will be somehow amenable to the whips of that particular political party. So curbing this practice, here the Dinesh Goswami committee has given this significant recommendations. Apart from this, the Dinesh Goswami committee has also recommended that the power to decide the disqualification should be vested in the president or the governor, as the case may be, and who shall act on the advice of the election commission. Because what is happening under the scheme of the 10th schedule, that if any member has been incurred in disqualification or any complaint has been lodged regarding the disqualifications of the elected members of the legislative assembly or legislative councils or to the members of parliament, then that case here the speaker has been given the final word. So speaker has to take a decisions regarding disqualification member. And what has been seen in the practice is that here the speakers are taking a long time in deciding as to whether the member has incurred disqualification or not. So here the speaker of the house or the chairman of the house, as a custodians of this august office, is expected to act in totally impartial manner, and they are supposed to take a very prompt decisions. But because the political considerations or because of the some kind of the advice unofficially which was given by the government of the day, they are taking undue time in deciding about the disqualifications. And sometimes if the no confidence motion has been move against the government, and if the government is apprehending troubles by the such kind of members, then that case they somehow solicit or prevail over the speaker, and the speaker is taking prompt decision just to simply disqualify such members before the no confidence motions or the confidence motion is being considered by the respective house. So here the Dinesh Goswami committee has suggested that this issue is to be left to the president, and the president will decide on the advice of the council of ministers. And the third significant recommendation which was given by the Dinesh Goswami committee was that the whip issued by the political party should be made binding only in the case of the passage of the confidence motions, no confidence motions, money bill, and vote of thanks of the president or the governmental address. And then no other case here this whip is to be made mandatory. Apart from this, you also have to keep in mind with respect to the anti-defection law that suppose if there is a elections to the member of Rajya Sabha, and with respect to elections to member of Rajya Sabha, if any political party has issued whip directing the members of that political party to vote either in favor or against a particular candidate, and even that candidate has violated the whips or direction which was given by such political party, then with respect to the elections to the member of Rajya Sabha, here such deviant members will not come within the purview of the anti-defections law. For curbing this kind of practice and just to ensuring that the elected members of the political party must fall in lines and they must abide by the policy and principles of political party, then definitely in that case here it should be extended to such cases also. Because if you see the history of Indian parliamentary elections, then elections this country has been invariably fought on the party lines, and before elections every political party is declaring their election manifesto, and that election manifesto the political party make a certain kind of promise to the electorate that once their political party will be given the mandate, then and once they will come into government, then they will try to implement the promise which they have made to the electorate. So here, and in case of the elections to the Rajya Sabha member, here this is not applicable. So definitely it has the potentiality of the just somehow encouraging the elected members of the political party to altogether adopted lines which are altogether different. And if you see the unofficial estimate, then there is a allegation that in the elections for the members of Rajya Sabha, a lot of the monetary consideration, other considerations come into play. So just to curbing this kind of unethical practice, here the the scope of the whip has to be extended with respect to the such matters also. Here the provisions of anti-defections law was also being considered by the national commissions to review of the working of the constitutions, which was constituted by the BJP government under the chairmanship of Dr. The Venkat Chalaiya, and that committee has also suggested, because here the suggestions was that even they have gone to the extent by saying that the 10th schedule of the constitution has to be deleted because it has completely failed to achieve the objective which was stated by the which was stated in the statement of the object of the 52nd Amendment Bill. And what was being observed by the Venkat Chalaiya Commission was by saying that it has successfully combated the individual defections, but failed to check the group defections. So therefore, this panel has suggested that the apart from the just checking the scope of defections, here the size of ministry has to be restricted not more than 10% of the total membership of the Lok Sabha or Legislative Assembly. Because after the emergence of the multi-party political system, here we have come to the stage where some of the political party may have the very few members in the parliament or state legislatures, and here the provisions of the 1/3 split is now being repealed by the 91st Amendment Act in 2003, but there is only scope for the merger if it is being supported by the 2/3 of the members of that political party. Just securing 2/3 membership is a very difficult assignment if you consider it in context of the bigger political party or the political party which are having the significant numbers in Lok Sabha or Rajya Sabha. But what about the smaller political party which are having the very few members? In some cases they are having just 2-3 members. So in that case it is very easy to somehow take the or to solicit the confidence of the 2/3 in case of the smaller political party. So it has not altogether eliminated the scope of the defections in case of the smaller political party. As far the, if you see the approach which was being adopted by the parliament with respect to the, in view of the various suggestions or recommendations which was given time to time by the election commission, Dinesh Goswami commissions, then the commission on review on the working of the constitutions. Here some significant change was being introduced by the parliament by the 91st Amendment Act in 2003, and the first significant change which I have already discussed along with the exceptions to the provisions of the 10th schedule of the constitutions, and it was here the 91st Amendment Act has deleted the para 3 of the 10th schedule of the constitutions pertaining to the exemptions from disqualifications in case of the 1/3 split. So now that the scope of the 1/3 split is no more under the Indian constitutional scheme. And apart from this, the 91st Amendment Act has also provided the measures regarding the size of the Council of Ministers, and what is prescribed that the size of the Council of Ministers in union government and in state government should not be more than 15% of the total members of the lower house of the parliament or state legislature, except in case of the smaller state like the Sikkim, Mizoram and Goa, where having the strength of 32, 40 and 40 respectively. Here the maximum size of the Council of Ministers has been fixed to 12. Apart from this, here the 91st Amendment Act has also provided the person disqualified under the anti-defection law shall not be appointed as a minister or not hold any remunerative post unless he get re-elected. So these are some of the piecemeal legislations or some of the measures which has been taken by the Parliament for the purpose of strengthening the provisions of anti-defections law, but still lot needs to be done with respect to the provisions of the anti-defections law for the purpose of altogether checking the scope of the defections which may be followed by the which may be adopted by the elected members of the parliament or state legislatures. So after discussing this, now I am coming to the other significant provisions, that is the provisions pertaining to the parliamentary privilege. And if you see the provisions of the parliamentary privilege under the Indian constitutional scheme, then here the provisions pertaining to the parliamentary privilege is being specifically provided by the Article 105 as well as Article 194 of the Indian Constitution. Article 105 deals with the power, privilege and immunity to the elected members of the parliament, and Article 194 deals with the power, privilege and immunity of the elected members of the state legislatures. So, first instance you try to understand as to what is the meaning of the terms parliamentary privilege. So, as far the terms parliamentary privilege concerns, here it has been defined or it connotes the some of the peculiar rights enjoyed by the each house, that is the Lok Sabha or Rajya Sabha collectively as a constituent part of the parliament, and by the members of each house individually, without which it would be impossible for the either house to maintain its independence of actions or dignity and efficiency of the sovereign legislature. So, as far the terms parliamentary privilege concerns, here the parliamentary privilege can be discussed or explained in two contexts. First, in the context of the privilege which was enjoyed by the house collectively, and the second, the kind of the power, privilege or immunity which was being enjoyed by the elected members of the parliament or state legislatures in their individual capacity. So, as far the parliamentary privilege concerns, here this privilege attached to the Lok Sabha or Rajya Sabha not because of the any executive positions of the members, but they are considered absolutely essential to regulate its own proceedings in a disciplined, efficient and undisturbed manners, and in order to indicate its authority as well as dignity. So, as far the parliamentary privilege concerns, here broadly it has been divided into two categories. First, the kind of the privilege which was enjoyed by the members individually, and second, the privilege that belongs to the each house, that is the Lok Sabha or Rajya Sabha, or to the state legislative assembly or state legislative council, and that is being enjoyed in the capacity of the collectively. So, as far the individual's immunity, power or the privilege of the members of parliament is concerned, here it can be broadly divided into the three categories. That is the first, the kind of the privilege or immunity which was enjoyed by the elected members of the parliament in their individual capacity as a freedom of speech on the floor of the house. Second, the kind of the privilege or immunity which was being enjoyed by the elected members of the parliament or state legislature with respect to the arrest or imprisonments under the civil proceedings, and apart from this they also being given exemptions from the attendance as a jurors and witness in any case. So, these are the kind of the privilege which has been conferred to the members of the parliament in their individual capacity. So, first I am coming to the kind of privilege which was enjoyed by the members in the individual capacity, and in this context first I am taking up the kind of the immunity or freedom which has been given to the members of the parliament or state legislatures under the Article 105 clause 1 of the constitution, as well as under Article 194 clause 1 of the constitution in case of the elected members of the legislative assembly or legislative councils. And if you see the provisions of Article 105 clause 1 of the constitution, then it provides that the subject to the provisions of this constitutions and the rules and standing order regulating the procedures of the parliament, there shall be freedom of speech in the parliament. So, here the first thing which is being prescribed by this provision, that the elected members of the parliament has been given the freedom of speech on the floor of the house. So, whatever he say inside within the four wall of the house, then with respect to that he will not be subject to any kind of the proceedings or any kind of the actions either inside the house or even outside the house by the court. So, he enjoy the elected members of the parliament or state legislatures enjoy the absolute immunity with respect to the anything said within the four wall of the house. But here as far this the immunity is concerned, it is confined only to the whatever he said on the floor of the house. if the elected members of the parliament goes out of the parliament and if he repeat the same thing outside the parliament, and if that statement happens to be defamatory statement, then definitely in that case they will be amenable to the provisions of the court as well the provisions of Indian Penal Code. And if that statement happens to be defamatory statement, then that case he will be liable to be prosecuted under the section 500 of the Indian Penal Code pertaining to the defamations. So, as far this provisions concerns, here this is not an absolute provisions, and as far this provision as far the freedom of speech of the members of parliament is concerns, here this provision is subject to the provisions of the constitutions as well as the standing order regulating the procedures of the parliament, and that is being specifically provided under the article 118, article 121, article 208, article 211 as well as the rules 349 of the Lok Sabha. And if you see the provisions of article 118, then it deals with the rule of the procedures. Article 121 deals with the restrictions on the discussions in the parliament about the judges' conduct. Article 208 again deals with the rule of the procedures of the state legislatures, and article 211 deals with the restrictions on the discussions in parliament about the judges' conduct. So, what is being prescribed by this provision, that here the members of the parliament has been given the absolute freedom inside the four wall of the house. So, here the basic objective of according this kind of the freedom to the elected members of parliament or state legislature, that here the elected representatives should have the absolute immunity from expressing any view or any opinion with respect to any matters on the floor of the house. So and this kind of freedom is being given, so he will the elected members will not subject to any kind of intimidations, and he will not be liable to any kind of proceedings by the court. So, as a representative of the peoples, they will have the absolute freedom to express the grievances or the concerns as a elected representative of the people of this country, because we have adopted a system of indirect democracy where the electorate of this country are electing their representatives, and their representatives has been given the rights to legislate on the behalf of their electorate, as well as they also have to say with respect to the important policy matters which the government may consider. So, as far this provision is concerned, here this provision is also similar to the kind of the privilege which was being enjoyed by the elected members of the House of the Commons in United Kingdoms, and entire provisions pertaining to the parliamentary privilege has been adopted from the as per the constitutional practice in the British Parliament. But as far the speaker to the members of the parliament or state legislature is concerned, here it will confine only to the four wall of the house, but here it will not extend to the using any kind of the unparliamentary language inside the parliament. And if any members is using the unparliamentary language inside the parliament, then definitely in that case they will be subject to the proceedings by the speaker or the chairman of the house. And for this purpose the Lok Sabha has already formulated details rule, and that is being prescribed under article 349 to article that is being specifically provided by the rule 349 to 356 of the conduct of the proceeding of the Lok Sabha. So, here the elected members of the parliament or state legislature must have to keep in mind these rules which was formulated by the Lok Sabha, and they are having the absolute freedom to say anything on the floor of the house, but definitely in that case they will not be authorized to use any kind of the unparliamentary words or unparliamentary language inside the floor of the house. Apart from this, you also have to keep in mind that the elected members of the parliament or state legislature is not having any right to say anything regarding the conduct of the judges of the Supreme Court as well as the High Court, and they can discuss about the conduct of judges only if the parliament has initiated the proceedings regarding the removal of the judge of the Supreme Court and High Court. Otherwise, here the members of the parliament cannot comment upon the conduct of the judges, because here this provision is also having the salutary effect, because here we have adopted system of the separation of power, and we are having the three organs of the government, that is the executive, legislatures and judiciary. And as far the status of three organs of the government is concerned, here one organs of the government is not subordinate to the other organs of the government, and all three organs of the government are required to work in accordance with the provisions of the constitutions and in accordance with the limitation which is being prescribed by the provision of the constitution. So, one organs of the government cannot show that they are having the supremacy or primacy over the other organs of the government, and here the exercise of power by the every organs of the government has to be regulated by the specific provisions of the constitution itself. So, apart from this, here with respect to the Article 105 clause 1 is concerned, if you see the provisions of Article 105 clause 2, then say that no member of parliament shall be liable to any proceedings in court of law in respect of anything said or any vote given by him in parliament or any committee thereof. Now, you try to analyze the provisions of Article 105 clause 2. Here the very significant word which has been used by the constitution maker, that is the in respect of anything said or any vote given by him in parliament or any committee thereof. Here the scope of the word in respect of the things was considered in detail by the Supreme Court in P.V. Narasimha Rao versus state case, that is that this case is popularly known as Jharkhand Mukti Morcha bribery case. Here what happened in this case, that the P.V. Narasimha Rao was leading the minority government, and that point of time the equations of the Lok Sabha was such that whenever the no confidence motion was being moved by the principal opposition party, that is the BJP, then no political party was willing to align with the BJP, because nobody wanted to see that they are having the some kind of the tacit understanding with the right wing ideological parties such as the BJP, and whenever such no confidence motion was being brought, then that case here all the political party was simply boycotting when the no confidence motion was being considered by the Lok Sabha. But once the no confidence motion was being brought by the CPI, then that case the all political party had decided to support the no confidence motion, and in that case here the Narasimha Rao government was on threat of the proving their majority on the floor of the house. So somehow they it was being alleged that they have bribed to some of the members of the Jharkhand Mukti Morcha to vote against the no confidence motions, and here this fact was also being established. It was the admitted fact that the bribe was being given to some of the members of the Jharkhand Mukti Morcha as well as the others members of some other political party, and so here the court has to consider as to whether if any person is being bribed, but in that case a person who has taken the bribes and the person who has given the bribes, so what will be the consequence, whether the person who has accepted the bribes and after accepting the bribes or after taking the bribe, if such elected members of the parliament or state legislature has voted against the no confidence motion, within that case they will come under the purview of the parliamentary privilege, or they will be subject to the proceeding by the court under the Prevention of Corruption Act. Here with respect to this case, here in the P.V. Narasimha Rao case, here the Supreme Court has made a differentiations between the elected members of the parliament who is accepting bribe and giving vote either in favor or against the motions, then still he will not be amenable to the jurisdictions of the court, and he will be protected because of the provisions of Article 105 clause 2 of the constitution. And but if any elected members of the parliament after accepting the bribes, if he did not vote, then that case he will be amenable to the court jurisdictions, and the persons who are giving the bribe they will also be amenable to the court jurisdictions. So if you see the kind of the guidelines or the strictures which was being made by the Supreme Court in the Jharkhand Mukti Morcha case, Jharkhand Mukti Morcha bribery case, here the first the significant things which was stated by the court in context of the parliamentary privilege, that the bribe taker MP who had voted in parliament against no confidence motions were entitled to protections of Article 105 clause 2, and were not answerable in court of law for any alleged conspiracy and agreement. So, see the kind of interpretation which was given by the court with respect to the scope of the Article 105 clause 2 by saying that if the person is taking bribe and they are voting against the no confidence motion, still he will be protected by the provisions of Article 105 clause 2. And the court further stated that, but if the bribe taker MP who did not vote on the no confidence motion was not entitled to protections under Article 105 clause 2 of the Constitutions. Apart from this, the Supreme Court also stated that for the bribe givers MP, the protections of Article 105 clause 2 is not available. So, apart from the clearing the constitutional provisions regarding interpretations to the words in respect of the things done, either the form of the voting or the speech in the parliament under the scope of the Article 105 clause 2. Here the one of the very significant things which was stated by the judiciary in this case is that by saying that the Lok Sabha could take actions for the breach of privilege or contempt against the alleged bribe givers and against the bribe takers, whether or not they were the members of the parliament. So, you can simply see the kind of interpretation which was given by the Supreme Court with respect to the provisions of freedom of speech which was being enjoyed by the members of parliament under the Article 105 clause 1 and 2, as well as the other the privilege which was being enjoyed by the elected members of legislative assembly or legislative councils. So, apart from this, and now coming to the kind of the privilege which was being enjoyed by the parliament with respect to the publications of its proceedings. And if you see the provisions of Article 105 clause 2, then it says that the right of the publications of the proceeding, that no person shall be liable in respect of the publications by or under the authority of either House of Parliament of any report, paper, votes or proceedings. So, as per the provisions regarding the publication of proceeding is concerned, here the basic objective of incorporating this provision is that it would be matters of the paramount public and national importance that parliamentary proceedings should be communicated to the public which has deepest interest in knowing what is being passed in the parliament. So, with respect to this, here the parliament has enacted the Parliament Proceedings Protections of the Publications Act 1956, and here this provision has prescribed that the no civil or criminal liability may be incurred by any persons for publishing substantially true report of the parliamentary proceeding unless it is being expunged by the order of the speaker or the chairman of the house. So, as per the provisions of the parliamentary proceedings, the protections of the publication 1956 is concerned, here this provision was being deleted at the time of this provisions was being repealed at the time of emergency, and here if you see the detailed provision, then here this kind of provision is being incorporated to somehow that the members of the public or the electorate must know as to their elected representatives what is doing on the floor of the house. So, they are having the absolute they are the any person who is publishing the substantially true report of the proceeding, then that case they will be protected from the any kind of the actions by the parliament. And with respect to this, here the because basic objective is that here the parliament is the sole guardian. So, the parliament has the absolute power to decide as to whether any of his proceeding is to be published outside or not. So, but what is prescribed that if any of the part of the proceeding is being expunged by the order of the speaker or the chairman, then definitely in that case, if anybody is publishing anything pertaining to that matter, then definitely in that case they will be amenable to the contempt of the house, as well as they will also be amenable to the jurisdictions of the court. So, unless it is proved that it is without malice. So, here the person has been given the press, as both the print media as well as the electronic media has been given right to publish the substantially true report of the proceeding of the house unless it is being shown that such proceeding is actuated by the malice. If it is actuated by the malice, then that case they will not have this kind of immunity from the proceeding of the house as well as the proceeding of the court. So at the time of emergency, this provision was being repealed. Then again this provision was being reenacted by the Constitution's 44th Amendment Act in 1978, and this provision was being given the solid foundations by the specifically adding the Article 361 A to the Constitutions, and the Article 361A of the Constitution clearly provide that the protections of the publication of proceeding of the Parliament and state legislature, and it clearly states that the no person shall be liable to any proceedings civil or criminal in any court in respect of the publications in newspaper of the substantially true report of the proceedings of the either house of the Parliament or the state legislatures as the case may be, and unless the publication is proved to have been made with the malice. So this is the kind of the privilege which was given to the house collectively, and no one can publish anything without the specific consent of the house. So apart from this certain other kind of the privilege which was accorded to members of the Parliament, and that is one of the things that pertains to the freedom from arrest. And if you see the provisions of Article 105 clause 3 of the Constitutions, then it is being prescribed that a member of Parliament cannot be arrested or imprisoned in civil proceedings within 40 days before and 40 days after the sessions of the Parliament or House. Apart from this, here the specific duty is being imposed on the retaining authority under the rule 261 of the Lok Sabha, where it is being prescribed, the duty is being imposed on the retaining authority to communicate to the House the reason for the arrest or detentions, the time of the arrest, the place where he is being detained or the imprisons, and the period for which the member is being arrested or retained. So here this provision is made, so if any person being arrested, he cannot be arrested within 40 days of the sessions or after the 40 sessions, so he will be free to attend the sessions of the House. Apart from this, here the other privilege which has been given to the House is that the right to exclude the strangers. And if you see these provisions, then there this right to exclude the strangers or the non-members, and here the Parliament is also having the power to go for the secret sessions, and that was also being exercised by the Parliament in the past also. So as far the power to exclude the strangers concerns, here this provision is being incorporated purely for the purpose of altogether excluding the scope of any kind of intimidations by the members, by the any others members who are not members of the Parliament or state legislature. So as far the right to exclude the strangers concerns, here it has to be specifically regulated by the provisions of rule 248 of the Lok Sabha, which empower the chair whenever he thinks fit to order the withdrawal of the strangers from any part of the House, and when the House was sitting in secret, then the no stranger is allowed to be in the chamber, lobby, or even the gallery of the House. Apart from this, here the members of the Parliament is also being given the certain kind of the privilege or immunity with respect to the right to prohibit the publications of proceedings, and this issue was specifically being considered by the Supreme Court in the Searchlight case, that is the MSM Sharma versus SK Sinha case. And here what happened in this case, that the editor of the weekly was being punished for the contempt of the Legislative Assembly of the Bihar state legislature for publishing those part of the speech of the member which was specifically declared to be expunged by the order of the speaker. So in this case, in Searchlight case, the Supreme Court has clearly stated that the action taken by the speaker against the editor is very much similar to the kind of the privilege which was being enjoyed by the House of Commons England. So here this power or privilege of prohibiting the publications, even the true and the faithful report of the debate or proceedings took place in the House, but if it's only if it is being expunged. So once it has been declared expunged, then that case no one will have any right to publish anything pertaining to that matters. Apart from this, here the both House of the Parliament as well as state legislatures also have been given the privilege or immunity with respect to the regulating the internal proceedings. And with respect to this, here what is prescribed that under Article 122, that if any irregularity is being complained with respect to the proceeding proceeding of the parliament or state legislatures, then it cannot be questioned before the court of law, and with respect to that matters, here the parliament will have the absolute power to take all the necessary actions regarding the such irregulatory proceedings. Because if you see the constitutional scheme, then under the constitutional scheme, here the president or the governor has been given power to summon the house. So apart from the summoning the house, here the governor or the president is not having the any power to decide as to how the proceeding of the house has to be regulated or conducted. So it is entirely for the chairman or the speaker of the house, concerned house, to decide the manner with respect to be the proceeding of the house has to be conducted. So if any member has committed any kind of breach, or they have committed any kind of contempt with respect to the proceeding of the house, then definitely in that case they will be taken to task. So apart from this, we are also having the certain provisions regarding the privilege to the members of the parliament, as well the provisions regarding the fundamental right. So as per the provisions of article 105 clause 1 is concerned, which pertain to the freedom of speech and expressions, here this provision is independent right, and somewhat it is absolute in nature, and it is not subject to reasonable restriction which is prescribed by the article 19 clause 2 of the constitution. But with respect to the arrest or imprisonment, definitely they will be subject to the jurisdiction of the court under the article 226 as well as article 32 of the constitution. Apart from this, we also had the certain issue regarding the scope of the judicial interventions and the power of the court, and that we have to take I think the time will not permit us to proceed the details, but definitely next class, if the time will permit, then we will give you some idea about the kind of privilege which was being enjoyed the members of the house and the status of the court with respect to the parliamentary privilege or immunity. But today I don't think the time will permit. Yes,
we had short of time over here, and dear friends, we would be meeting again and would be discussing further in our future sessions. Till then, I would say that if you have any queries, then you can mail us at info.cc@nic.in. We would be meeting again. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.
Thank you, Vitka. Thank you, listeners.